Today, we're diving into a fascinating legal battle. It all started with a simple homeowners association election, but it ended up in a full-blown court case. It's a story all about neighborhood politics, what happens when rules get bent, and it brings up one huge question. And that question is, who really gets to decide the rules where you live? I mean, what happens when the official bylaws say one thing, but the way things have always been done is something totally different? Who gets the final say? Well, a recent case out of Arizona puts that exact problem right under the microscope.
So, here's our game plan. First, we're going to meet the people involved and set the stage for this whole showdown. Then, we'll get into the real meat of the dispute, a deadline that nobody could agree on. After that, we'll look at just how much power a nominating committee actually has. And finally, we'll get to the good part, the judge's final decision.
All right, let's get into it. On one side of the ring, we have William Travis. He's a homeowner, and at the time, he was also a board member. And on the other side, the Val Vista Lakes Community Association. The whole fight was over one thing: the board of directors election that happened back on November 16th, 2017. Okay, so this is where things start to get a little messy. The election gets announced and there's a deadline of September 29th. Seems straightforward, right? Well, that deadline comes and goes with only 4 applicants. But then the association just keeps accepting applications. 4 more people, including our guy Mr. Travis, get their names in. Now, Travis tries to make it official. He actually makes motions to formally extend the deadline, but the board shoots him down. So now you've got this weird situation. 8 people applied in total, but when Election Day rolls around, a committee has decided only 4 of them will actually appear on the ballot. And that's where the fight really kicks off. So Mr. Travis takes the HOA to court, and his case really boils down to 3 main complaints. First, he says the nominating committee totally ignored a deadline that was a firm rule. Second, he argues they had no right to interview candidates, saying they were basically just making up new qualifications on the fly. And third, he claims they broke the law by not putting every single qualified person on the ballot. Okay, so let's dig into that first point, because it's a biggie. That September 29th deadline, was it a hard and fast rule, or was it more of a soft guideline? Pretty much everything depended on the answer to that question. As you can imagine, the 2 sides saw this completely differently. From Mr. Travis's point of view, that deadline was a formal rule adopted by the board, period. And ignoring it was a clear violation of the bylaws. But the HOA, they said, whoa, hold on. They claimed it was just an administrative deadline set up by their management company for one simple practical reason: to make sure they had enough time to get the ballots printed. And here's the piece of testimony that pretty much settled this part of the argument. The association's manager, Simone McGinnis, got up and said, point blank, that the board never actually voted on or imposed that deadline. She said it was just a logistical thing created by the management company. The judge pointed out that Mr. Travis really didn't have any evidence to prove otherwise. Okay, so the deadline argument didn't hold up. But what about Mr. Travis's other points? This really gets us to the absolute heart of this whole case. What power does a nominating committee actually have? Are they just supposed to be a rubber stamp for every application that comes in? Or can they actually act as gatekeepers? Travis's argument was pretty simple. He said the committee's job is just to put every single applicant on the ballot, full stop. By asking them questions and interviewing them, he said, they were basically inventing new hurdles that weren't in the rules. But the HOA fired right back. They said, no, interviewing candidates is a totally normal part of exercising our discretion to select the best possible nominees for the community. So what did the actual rules say? Well, the judge went straight to the source, the HOA's own bylaws. And there was this one sentence in Article 4, Section 3, that changed everything. It says, the committee can make as many nominations as it shall in its discretion determine. That one little word, discretion, was basically the nail in the coffin for this part of the argument. But Travis had one last card up his sleeve. He argued that by filtering the candidates, the committee was essentially casting votes for the members by proxy. His logic was that they were preventing homeowners from voting for the people who were excluded. He claimed this violated a specific Arizona state law, ARS 33-1812, which deals with proxy voting. All right, the arguments have all been made. The evidence has been presented. So, what was the final call? How did the judge rule on all this? The judge basically took Mr. Travis's claims and dismantled them one by one. First, that deadline,
Nope, purely administrative, not a formal rule. Second, the committee's power to pick and choose, yup, totally within their rights because the bylaws explicitly give them discretion. And third, that state law about proxy voting, the judge said choosing a nominee isn't the same thing as a vote, so that law just doesn't apply here.
And with that, the final order was simple, direct, and to the point. William Travis's petition was dismissed. The HOA and its nominating committee won on every single count.
So what's the big lesson here? What should we all take away from this? Well, the judge's decision is a huge reminder of a really important legal idea. HOA bylaws aren't just a friendly set of suggestions. They are a legally binding contract between the association and every single member. The final decision in this case didn't come down to what felt fair or what was traditional. It all came down to the very specific words written in that contract, the bylaws.
And that brings us right back to where we started. This case is a perfect example of how, in any community association, the real power is hiding in the fine print of its governing documents. It's not about what you think the rules are. It's about what they actually say word for word. Which kind of leaves us with one last really important thought. Do you know what your HOA's bylaws really say?